One of the questions that comes up often in my daily work as a solicitor in doing employment law is the question of whether a person is an employee or an independent contractor. And there has been various decisions down through the years, including the Henry Denny case and various other very, very important decisions. But most recently there's been a Supreme Court decision involving the so-called Domino's pizza drivers or delivery drivers case. And in October 2023, the Supreme Court issued a determination about how to go about assessing a case of whether a person is an independent contractor or whether a person is an employee. And the Revenue Commissioners then have issued a guideline, a booklet, and I will put a link below this video on my YouTube channel to the booklet itself. But essentially there are 5 questions that need to be asked. These questions arise from a sort of a framework, a sort of a methodology by which the Supreme Court has suggested a person would make a decision as to whether a person is an employee or an independent contractor. So let's take a look at the 5 questions. So the decision-making framework arising from the Supreme Court decision in that case involving the Domino's pizza delivery drivers. The 5 questions are as follows. 1. Does the contract involve the exchange of wage or other remuneration for work? This is commonly known as the work/wage bargain. Number 2. If so, is the agreement one pursuant to which the worker is agreeing to provide their own services and not those of a third party to the employer? This is more commonly known as the personal service test. And number 3, if so, does the employer exercise sufficient control over the putative employee to render the agreement one that is capable of being an employment agreement? This is known as the control test. If these 3 requirements are met, the decision maker must then determine whether the terms of the contract between the employer and worker, interpreted in the light of the admissible factual matrix and having regard to the working arrangements between the parties as disclosed by the evidence, are consistent with a contract of employment or with some other form of contract having regard in particular to whether the arrangements point to the putative employee working for themselves or for the putative employer. So all of the circumstances of the employment would be looked at, all the evidence would be looked at after the first 3 questions. Finally, number 5, it should be determined whether there is anything in the particular legislative regime under consideration that requires the court to adjust or supplement any of these foregoing issues or questions. The first 3 questions that I have set out are to be viewed as a filter. If any of these questions, if the answer to any of these first 3 questions is no, there cannot be a contract of employment. If the first 3 questions are answered yes, questions 4 and 5 must then be considered to determine if a contract of employment exists or not. Now, there is a decision tree setting out these 5 questions in the revenue booklet issued on the May 2024, the Revenue have issued a booklet called Revenue Guidelines for Determining Employment Status for Taxation Purposes. It focuses on and is derived from the Supreme Court decision in that Carshan Midlands case, trading as Domino's pizzas, drivers or whatever it is, trading as Domino's pizza. And the Revenue Guidelines for Determining the Employment Status for Taxation Purposes is a 58-page booklet. It is very useful, very detailed, and I will put a link to that booklet at the end of the video on my YouTube channel. I hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below. Thanks a lot.